Hi, I'm Mal from the Money Study, bringing you another episode of our Take 10 Challenge, number 56, all about estate planning. So there's my disclaimer, facts and figures, information only. It is not advice in today's session. This is just a bit of a brief look at all the issues relating to estate planning. We'll come back to all these things in future sessions, a bit more detail, but it's important that we get a bit of an overview of what's required. And it's certainly an area that a lot of people just do not take into consideration and leave all these things to another day. They just don't like thinking about it, or they don't know how to do it. It's all too hard, and they just leave it. And of course, if they pass away or something happens, it literally leaves a big problem for the surviving people. So, a will. Yep, what we're doing here is we're basically letting everybody know that when we die, this is where we want our money to go to. Now, if you are in what I would call a I love you situation, meaning you've got a partner, perhaps a couple of kids, you could do a very simple will. You could even buy just a will kit from the post office or online and do I die. She gets it, she dies, I get it, we both die, the kids get it, and it can be very, very simple. But if it's a situation that there are more complexities to it, especially if you've got things like kids from previous marriage or de facto relationships, or an ailing parent, or something that really is a little bit unusual and makes it a bit more difficult to work out how your money is going to be distributed after your death, I would strongly suggest that you go and talk to a legal practitioner and get one who's specialising in will, someone who does look at estate planning. It can be exceedingly difficult if you've got blended families, and I do believe that it's almost impossible to get a will that's going to be seen by everybody as being appropriate. There'll always be someone who's got may perhaps get their knickers in a knot when they see that they think this is unfair or unjust, literally because of their perspective on the whole situation. So having a very well outlined will, and can even have your reasoning behind your decisions in that will, so therefore it can be acted upon without too much grief. And in fact, if you can actually sit down with your beneficiaries before you die and perhaps explain your scenario and your thinking and so forth, so there can be a bit of clarity, not after in the situation of while they're dealing with their grief at the same time. But a will needs to cover across all of your assets, so your house, your bank accounts, your savings, your investments, and so it goes on. Remembering that anything that's in a joint account, so if you and your partner have joint bank accounts, that is something that is not controlled by the will. A joint owner literally just receives the account, it's theirs. A joint account will not then go to the estate and be treated by the will. So this is where it can be quite handy to have joint accounts as a couple, meaning you don't have to wait for processing of wills and so forth, because obviously if you've got an individual account and there's a death, some bank accounts can get frozen until such time as the reading of the will has been done. We'll go through this in future sessions, a bit more of the processes and things involved at a later time there. But get a will kit, at least have something to. Therefore, you don't die what they call intestate without a will, that we've got something there to give the people some sort of guidance to go forward. You are going to need an executor. Now, this is where it gets very interesting. Do you choose a family member? Do you choose a professional? Do you use one of the companies that specialise in all of this? Various pros and cons. Okay, we'll talk about this in future sessions. Guardianship, I think, is exceedingly important, but something that a lot of people sort of don't get around to doing. It's basically what it boils down to is if perhaps you and your partner die in an unfortunate accident. You've gone out to dinner, celebrating an anniversary or something, the kids are at home with the babysitter, you have an accident and you never come home. Who is going to look after your children? So this is a guardianship arrangement to make sure who's going to look after your children. This can be a tough one because it's obviously got to be someone that perhaps you and your partner both agree is an appropriate person to bring up your children in the manner that you would like it to happen. It's got to be someone who can afford for it to be able to do it, and that's perhaps where your insurances and things may come into being, knowing full well that they couldn't, but with your insurances that's sufficient for them to be held, the money to be held in trust wherever to look after the children. And of course, there's got to be someone who wants to do it. And your children might be brats, and no one wants to look after them. But look, it's a case of you and your partner, if you've got a partner, sit down, look at what the different options and so forth. It does not have to be a family member, that's for sure. It could be a close friend or even a good neighbour. Someone who obviously has got a good relationship with your child would be handy, but someone who understands what you're doing. Guardianship can be done to a point where you just need to provide them with some sort of a guidance. You can do a memorandum of wishes, so that which you can just update regularly. So it could say that yes, we'd like our child to have piano lessons at age 12. We'd like them to have horse riding lessons when they're 16 or whatever it may be. So therefore, by doing a memorandum of wishes, you can just replace that as time goes on. Obviously, as they hit different age thresholds, different ideas, different things are required, and so forth. So it's usually a case you sit down with your guardian, future guardian, to making sure that they really understand where you're coming from and what you'd like to happen in the future if needed be. Powers of attorney are literally where someone can act on your behalf, be it you're either perhaps you're overseas on holidays. Always a good idea to have someone back in Australia, perhaps if you're travelling overseas, to be your power of attorney in case something does urgently pop up that needs a signature. Ideally, perhaps you make each other, you and your partner, can be powers of attorney plus a friend. So you've got a second power of attorney in case you're both overseas, or so it goes on. A power of attorney can cease if you become unable to, you lose your mental capacity. So quite often that's when you need a power of attorney. So if you're looking for that sort of scenario, you need what's called a enduring power of attorney, so that they are still your power of attorney if you are unable to make decisions on your own behalf. And I think that's probably worth the effort to ensure that your power of attorney is an enduring power of attorney. Again, it's obviously going to be someone you trust, that's for sure, because they're going to be signing off on things. And you can limit the what they can and cannot have power over. So a bit of thought pattern got to go into that as well. And you can have guardians and powers of attorney and so forth, as say, looking at various different aspects of your personal situation and your children and so forth. So under those circumstances, I would normally suggest that you do go and talk to a solicitor to get these things organised. A normal will kit will indeed handle guardianship. There's usually a question who wants to do it and so forth. Powers of attorney, you can just normally go to the website per state. Powers of attorney are only per state. That's not a Commonwealth thing. So you just look up powers of attorney for your jurisdiction to find out the paperwork required. Normally not an expensive thing to actually get a powers of attorney in place, but make sure that your power of attorney knows what the situation is and got copies of the documents so that they can actually act upon it if they do need it. Remembering that if you pass away, your superannuation has got absolutely nothing to do with your will. Your superannuation is a trust. Hence, if you die, the trustees have got discretion to give the money to whoever they believe is the most appropriate person. You need to nominate inside your super fund who you want the money to go to. So your will could say your money goes to Joe Bloggs, but your superannuation could say your super goes to your child or your partner or whatever the case may be. So it just literally comes down to what your nomination says. Now, normally with a binding death nomination, you can only nominate your partner or children or someone who's got a financial interdependency relationship with you. So if that's the case and you want to nominate your sibling or a cousin or a nephew or whatever the case may be, on those binding death nomination forms, there would indeed be a box normally that says, tick the box that says I elect my legal representative for my superannuation. And what that means is they will indeed send the money to the estate. They'll send it to your will, and therefore your will would then handle it. But you've got to tick that box to have your superannuation to indeed go to that. Otherwise, the trustees of the super fund have discretion. I mean, normally, husband or wife, look, 99% of the case that would be a done deal. They would normally ask for a copy of the will as well anyway to give them some form of direction. But if they could see on your will that you did not want money to go to your partner, or you did not want money to go to a particular child, then they would certainly take those things into consideration. But they would do their own sort of investigation, and if there was no really good reason why money shouldn't go to a particular dependent, then they could override your decision. But not with a binding. A binding, you can see there are two nominations. There's a death nomination, but there's also a binding death nomination. If you nominate, yep, that's giving direction to the super fund, but it's not binding. The super fund can still override it. If you do a binding death nomination, no, that's it. They have to give it to the person that you've nominated or to the estate. Binding death nominations expire every 3 years, and they would need to be redone and updated just to make sure your situation hasn't changed. So this is a bit of an overview. We certainly will be coming back to these things in more detail as we go on with future sessions. Look forward to you joining me in future sessions.